Good afternoon. My name is Kim Stanger. I'm the head of the firm's Health Law Group, and thank you for joining for our webinar today on the Idaho abortion law, an update on kind of what's going out there. It's an interesting time. It seems like there's changes almost on a weekly basis, if not a monthly basis. So the goal here is to give you kind of a quick overview of where we are when it comes to that. You should have received a link with the PowerPoint slides. If you haven't, just reach out to Charles. I gave you his email and the chat feature there. Also, because we are recording it today, we won't take questions during the webinar, but you're welcome to submit those questions using the chat feature. You can just email me offline and I'll respond offline. With that said, let's get into talking about where we are with the abortion statutes. Before we get there, in the materials that I provided to you, in the PowerPoints, there's a bunch of written resources I think that would be very helpful, including the actual statutes themselves, some of the significant decisions that have come down from the court, and then I've also written a whole series of client alerts on the abortion statutes. Just remember that some of those have been modified a bit because of things that have happened at the Ninth Circuit last week, but I wanted to make sure that you were available and had those as a resource. All right, with that said, let's talk about the abortion laws. In order to understand our current situation, you have to kind of go back in time and understand how we got here. Idaho has prohibited abortions from the very beginning. Of course, that changed in 1973 with Roe v. Wade, which basically allowed, as a federal constitutional matter, allowed abortions under certain circumstances. In the wake of Roe v. Wade, over the years, the Idaho legislature had passed a whole series of different abortion laws trying to get around Roe v. Wade. But typically what would happen is they would pass it, it would be held to be unconstitutional, and so the next, a few years later, they'd try to pass a different statute. The bottom line is this: when they passed those statutes, so they never went back and took them off the books. So we have a whole series of different abortion statutes that were still on the books, most importantly of which was in 2020, Idaho passed its total abortion ban in 18-622. By its express terms, it stated that it would be triggered if the Supreme Court were ever to overturn Roe v. Wade. Kind of as an aside, I think what happened in a lot of these situations is moderate Idaho legislators agreed to pass these pretty draconian abortion bills because they thought that Roe v. Wade would never get overturned, and therefore they were willing to pass maybe more draconian bills than might otherwise have been in existence. So in 2020, they passed the total abortion ban. In 2021, they passed a fetal heartbeat ban, and that was triggered if federal courts uphold a similar fetal heartbeat ban. And in 2022, they passed an amendment to that fetal heartbeat ban that added a Texas-style private cause of action for family in the case of an abortion. Well, that's the way we were. Roe v. Wade was still in effect, and so I think people thought, well, they'd never really take effect. But guess what? Dobbs came out in 2022, and suddenly it overruled Roe v. Wade. That meant that the total abortion ban suddenly sprang into life, as well as the fetal heartbeat ban when that was upheld by a similar federal court. Not only that, all those other statutes that were on the books, they sprang back to life too. So they're out there. They don't always play well together. They don't always coordinate. And so we've got this kind of patchwork, this kind of mess out there with Idaho abortion laws in Idaho. That they overlap and then sometimes they conflict. As a practical matter, we're probably really only dealing with the total abortion ban as well as the fetal heartbeat ban. Now, the fetal heartbeat ban, it contains criminal penalties like the total abortion ban, but it specifically states that those criminal penalties don't apply to the extent that the total abortion ban takes effect. So the net effect of that is, under the fetal heartbeat statute, you don't need to worry about criminal penalties, but you still have to worry about that civil liability law. Now, after Dobbs and these laws took effect, sprang back into effect, there's been a whole series of lawsuits brought by Planned Parenthood and others challenging the laws. The first one was actually brought by the United States Department of Justice, arguing that the Idaho's total abortion ban was preempted by EMTALA. In, I think it was August of last year, Judge Windmill from the Idaho District Court preliminarily enjoined the enforcement of the Idaho total abortion ban in EMTALA cases. So it essentially created an EMTALA exception. Now, that was a preliminary injunction. The case is still pending. There isn't any final resolution, but Judge Windmill entered an injunction that prohibited the state from enforcing that total abortion ban in EMTALA cases. That's what we've been dealing with for the past year, but up until last week. And last week, the appeal went up to the Ninth Circuit, and at the Ninth Circuit, the Ninth Circuit overruled Judge Windmill's decision and enjoined the injunction that state enforcement of the EMTALA exception. So essentially what we have now is a situation where the EMTALA exception no longer applies, and at least preliminarily until that underlying case gets finally decided. Now, that Ninth Circuit decision, I checked this morning, the Department of Justice has filed an emergency motion for an en banc determination by the Ninth Circuit, basically appealing the Ninth Circuit panel's decision to a greater number of Ninth Circuit judges. That's supposed to be decided or heard on October 10th. So we're not sure exactly how that will play out. But in the meantime, until we get further decisions from the Ninth Circuit, then that there is no longer an EMTALA exception to the total abortion ban. Again, that case is still pending. We'd have to wait for a final decision, but that's where we are right now. In addition, a lawsuit was filed by Planned Parenthood with the Idaho, that made its way through Idaho up to the Idaho Supreme Court. And in January of this year, the Idaho Supreme Court issued its decision upholding Idaho's total abortion ban, fetal heartbeat ban, and the civil liability law. It did not address how those laws relate to the other laws that are on the book, but we know that at least the total abortion ban, the fetal heartbeat ban, and the civil liability law are not unconstitutional under Idaho law. We'll have to see how that goes up, if it goes up any further than that, but right now, those laws are constitutional and enforceable. In 2023, the legislature amended the total abortion ban, but it did not amend the fetal heartbeat ban. So I'll talk about those amendments a little bit later. They also enacted a new abortion trafficking law that I'll talk about later. Okay, so that's kind of the background. That's the litigation. That's where we are right now. Let's talk first about the total abortion ban. This is effective in Idaho. It states that it prohibits the abortion of a clinically diagnosable pregnancy by any person unless that abortion was necessary to prevent the death of a mother, and that abortion is performed in a manner to give fetuses the best chance to survive, unless doing so would increase the risk to the mother. So that's the first exception, if it's necessary to prevent the death of the mother. The second exception is if it occurs in the first trimester, if the abortion occurs in the first trimester, and the abortion, the mother was subject to rape or incest, and that rape or incest has been reported to the police, and a copy of that police report is given to the physician before the physician performs the abortion. What happens if you violate that? Well, performing or attempting to perform an abortion is a felony. It's 2 to 5 years in prison. In addition, attempting to perform, or assisting in an abortion is also can subject you to loss of licensure. During the first offense, the license is suspended for at least 6 months. For any subsequent offense, then it's a permanent revocation of the license. I'll talk more about what that means for assisting in an abortion a little bit later, but that is the total abortion ban. The trigger is whether or not there's a clinically diagnosable pregnancy. Now, the opponents to the statute argued that clinically diagnosable pregnancy is vague and ambiguous and shouldn't be enforceable, but the Idaho Supreme Court said no, that's been the standard for abortions for years and years and years, and therefore they rejected that. But they did give some important clarifications. In the statute itself, abortion is defined as the use of any means to intentionally terminate the clinically diagnosable pregnancy of a woman with knowledge that the termination by those means will, with reasonable likelihood, cause the death of the unborn child. In the most recent amendments, they modified it so it does not include the use of an intrauterine device or birth control pill to inhibit or prevent ovulations, fertilization, or the implantation of a fertilized ovum within the uterus, or the removal of an ectopic or molar pregnancy, or the removal of a dead unborn child. So in the 2023 amendments, they changed the scheme. Originally, as drafted under the total abortion ban, there were affirmative defenses for if it was necessary to save the life of a mother in the case of rape or incest, but those had to be asserted as affirmative defenses. That put providers in a bad situation because they were essentially violating the law by performing the abortion even in those cases, and then they would have the burden of proof of coming back and establishing that they satisfied these affirmative defenses. But the legislature modified that, so now those exceptions are simply outside the definition of what is an abortion for purposes of the statute. So it relieves the burden of the healthcare provider to assert those as an affirmative defense. Instead, the prosecution would have to essentially assert the absence of those situations. So the abortion statute doesn't apply in the case of ectopic or molar pregnancies or the removal of an unborn child. In addition to that, at the Supreme Court level, when this case went up to the Supreme Court clarified that as it interpreted the total abortion ban, because it only applies to a pregnancy is defined as the reproductive condition of having a developing fetus in the body and commences with fertilization. So because the statute prohibits an abortion of a clinically diagnosable pregnancy, and pregnancy only applies to a developing fetus, the Supreme Court said that to trigger the abortion ban, that fetus must be developing to fall under the definition of pregnancy. Therefore, non-viable pregnancies, that is where the unborn child is no longer developing, are plainly not within the definition of abortion as criminalized by the total abortion ban. So in addition to the statutory exceptions for ectopic pregnancy or the other molar pregnancy or the removal of an unborn child, the Supreme Court has interpreted that to add another exception, which it does not apply if the fetus is not developing. In order to trigger the exception for the abortions necessary to save the life of a mother, it not only has to be necessary to it has to be necessary to prevent the death of the mother. The question came up, well, is that an objective test or a subjective test or an objective test? And at the Supreme Court level, the Supreme Court said that that depends on the physician's subjective good faith medical judgment, not necessarily an objective standard, but the physician's subjective good faith medical judgment. The Supreme Court specifically said that the statute leaves wide room for the physician's good faith medical judgment on whether the abortion was necessary to prevent the death of the pregnant woman based on the facts known to the physician at the time. This is clearly a subjective standard focusing on the particular physician's judgment. The statute does not require objective certainty or a particular level of immediacy before the abortion can be, quote, necessary, end quote, to save the woman's life. Instead, the statute uses broad language to allow for the clinical judgment that physicians are routinely called upon to make for the proper treatment of their patients. So that provides some protection to physicians who are concerned about whether or not they can proceed with an abortion that they believe is necessary to save the life of the mother. When they are doing that abortion to save the life of the mother, the statute has kind of a weird provision in there that the abortion still has to be performed in a manner that gives the best opportunity for the unborn child to survive. At the Supreme Court, when they looked at this, they also said that standard also is a subjective standard and depends on the good faith medical judgment of the physician who's performing the abortion. Specifically, the Supreme Court said this means that if a woman is to have an unborn child removed from her body based on the preservation of her life, when the unborn child is viable outside of the womb, the physician must remove that unborn child in a manner that provides the best opportunity for survival. For example, a vaginal delivery or cesarean delivery, and cannot remove the child using a method which will necessarily end its life. For example, dilation and extraction or partial birth abortions. The exception to this is when the physician's good faith medical judgment, in the physician's good faith medical judgment, a method that would save the unborn child's life poses a greater risk of the death to the pregnant woman. So that's the standard for the total abortion ban. Okay, let's move on to the fetal heartbeat ban. This is that separate statute. Remember, this was enacted after the total abortion ban, but while Roe v. Wade still precluded both of those. Under the fetal heartbeat statute, it states that any person who intends to perform or induce an abortion must determine if there is any fetal heartbeat, except in an emergency, medical emergency. Now, the abortion statute for this one, the fetal heartbeat ban, has a different definition of abortion than the total abortion ban. And therefore, the Supreme Court's analysis of what is and is not an abortion under the total abortion ban does not apply to this 6-week ban. So you have to satisfy both of those. So under the 6-week ban, the abortion means the use of any means to intentionally terminate the clinically diagnosable pregnancy of a woman with knowledge that the termination will, with reasonable likelihood, cause the death of the preborn child, and it does not include the use of an IUD or birth control pill to inhibit or prevent ovulations, fertilizations, or the implantation of a fertilized ovum. Note that it does not, this particular statute, the fetal heartbeat statute, does not contain the exceptions for ectopic pregnancies or the like. It only applies if a fetal heartbeat's been detected. Fetal heartbeat means the embryonic or fetal cardiac activity or the steady and repetitive rhythmic contraction of the fetal heart within the gestational sac. Under the fetal heartbeat statute, it says a person may not perform an abortion when a fetal heartbeat has been detected, except if it's an emergency or a medical emergency. That means the abortion is necessary to avert the death of a pregnant woman or the substantial and irreversible impairment of a major bodily function of the pregnant woman. So note that the total abortion ban does not allow an abortion for the health of the mother unless it's necessary to save the life of the mother. The fetal heartbeat ban has a different standard. It has to be necessary to prevent the death of the pregnant woman, or it can also be performed if there's a substantial and irreversible impairment of a major bodily function of the pregnant woman. Also, it contains the rape or incest exception, just like the total abortion ban. So you've got these two different statutes out there, okay? Under the fetal heartbeat ban, however, the statute is written in a way so that the criminal penalties under the fetal heartbeat ban don't apply to the extent the total abortion ban applies. So when it comes to criminal penalties, you don't need to worry about the fetal heartbeat ban. You just look at the total abortion ban. However, the civil lawsuit portion of the fetal heartbeat ban still does apply. So if you're talking about criminal actions, you just look at the total abortion ban under 18-622. If you're talking about civil lawsuits, then you have to look at the standards that apply under the fetal heartbeat statute. That means all of those standards we just talked about, that the abortion can't be performed if there's a fetal heartbeat, and except those exceptions, including the medical emergency exception under the civil lawsuit standard. Under the fetal heartbeat statute, it allows either the mother, the father, the sibling, grandparent, aunt or uncle or child may sue the physician or others who are involved in an illegal abortion. And if they win, they are able to recover $20,000 statutory damages, actual damages, and the costs and attorney's fees. In the Supreme Court opinion, they confirmed that $20,000 statutory damages, it's the minimum amount of damages. It's not you get $20,000 statutory plus additional actual damages on top of that. It's just the $20,000 is the minimum that you get. So if you were a physician or other person performing one of these abortions, then you can get sued by these family members if you're performing that abortion in contravention of the fetal heartbeat statute. Now, as I mentioned, it's got this medical emergency exception. Again, that means a condition that in the reasonable medical judgment so complicates the medical condition of a pregnant woman as to necessitate the immediate abortion of her pregnancy to avert her death, or for which a delay will create a serious risk of substantial and irreversible impairment of a major bodily function. So if you're performing an abortion you need, after a fetal heartbeat's been detected and you want to protect yourself from civil lawsuits, you need to make sure that you can satisfy this medical emergency standard, or that it's a case of rape or incest. Now, remember, under the total abortion ban, to save the life of the mother is a subjective test, depends on what the treating physician thought. Under the fetal heartbeat ban, the civil liability statute, it's an objective standard. The test is not what the treating physician thought, but what a reasonable physician would do. The Supreme Court confirmed that this standard requires the physician to exercise reasonable medical judgment when determining whether the medical condition of the pregnant mother necessitates an abortion to avert her death or avoid a serious risk of substantial and irreversible impairment of a major bodily function. That's an objective standard. It's not what that physician thought, but it's what a reasonable physician would do under those circumstances. Now, as I mentioned, because the definition of abortion is different under the fetal heartbeat statute, it does not contain statutory exceptions for ectopic pregnancies. But the Supreme Court, in its opinion, it basically said if you've got a termination of an ectopic or a non-viable pregnancies, that those likely fall within the medical emergency exception under the fetal heartbeat statute. And then, therefore, you would probably be able to avoid liability under the fetal heartbeat statute, even if it's an ectopic pregnancy or the like. Now, those are not the only statutes that are out there that provide civil liability statutes. There's other statutes that have actually been on the books for a while, including the 20-week abortion ban, the partial birth abortion statute, and the chemical abortion statutes. Those have been around forever, for a long time at least. And those also have private causes of action. It's just under Roe v. Wade, we never had to worry about them. Now, those are still out there. As a practical matter, to the extent that they conflict with the civil liability statute and the fetal heartbeat statute, I suspect that a court would likely state that the fetal heartbeat statute trumps these other statutes to the extent there's an inconsistency, because it expresses a prior legislative attempt condition. But to the extent that they don't necessarily overlap, it's possible that a plaintiff could try to sue you under one of these other statutes too. All right, those are the general bans. Let's talk about aiding, abetting, or assisting an abortion. The total abortion ban specifically says that a licensed professional who assists in the prohibited abortion can lose their license. The first offense, they lose it for 6 months. For subsequent offenses, the license is permanently revoked. Now, because that statute specifically says what the penalties are for assisting, and it's limited to licensed professionals, it appears that, at least under that statute, there would not be additional penalties for aiding or abetting or assisting an abortion other than the adverse licensure provisions. There are no criminal penalties identified under the total abortion ban. Well, the problem is, if you look at other statutes that predated the total abortion ban, for example, Idaho Code 18-606 says that an accomplice or accessory who aids in an abortion in violation of 18-605, it's a felony and you're in prison for up to 1 to 5 years. But 18-605 was the statute that was superseded by 18-622. So what does that mean? Does that mean that this accomplice or accessory statute is no longer in effect because the statute on which it's based is no longer in effect? I think that's probably likely how it shakes out. So this accomplice or accessory statute probably no longer exists. But what does that mean? Does that mean that therefore somebody who is an accomplice or an accessory can no longer be subject to a criminal statute? We don't really know. I suspect one would argue that the total abortion ban in 18-622, because they specified the particular liabilities for those who assist in a prohibited abortion, I suspect that the court may say that no, they changed it and it's only limited to those licensed professionals, and these are the penalties that are applied, but we really don't know. Now, as some of you may know, in March of 2023, Attorney General Labrador wrote a letter in response to a request from a legislator, in which Attorney General Labrador concluded that an Idaho healthcare professional who refers a woman across state lines to an abortion provider, or who prescribes abortion pills for a woman across state lines, has given support or aid to the woman in performing or attempting to perform an abortion, and thus has violated the statute, that statute that prohibits assisting in an abortion. Well, of course, that didn't sit well with Planned Parenthood and others. They immediately filed a lawsuit. Shortly after Attorney General Labrador issued that letter, he withdrew the letter, but that didn't necessarily stop the lawsuit from going ahead and continuing. In July 2023, as part of that lawsuit, Judge Windmill issued an order preliminarily enjoining Attorney General Labrador from enforcing that interpretation that simply referring a patient out of state or to get an abortion, that could not be used as a basis for the liability under the total abortion ban for assisting in an abortion. That is a preliminary injunction that is currently in effect, but that case is still pending. And I believe that there's supposed to be additional briefing on that, although I haven't looked at the briefing schedule recently. So stay tuned on that one. Significantly, I think part of the concern that Judge Windmill had in this is the state argued that because that letter, the March 2023 letter had been withdrawn, that it really has no precedential effect, and therefore the court really didn't have any jurisdiction in order to enjoin enforcement. But at least according to Judge Windmill, the AG's office had never disavowed that interpretation. And so the concern is that because they haven't disavowed the interpretation, it's possible that that might be used to prosecute somebody because of that, or at least take adverse licensure action against them for assisting simply because you refer somebody out of state. They still, to my knowledge, have not disavowed that. So it's still an issue out there. We'll have to watch and see how this case plays out. Now, separate apart from the aiding and abetting statutes, the assisting in abortion statutes that exist on the books, there's the general criminal statute that says all persons concerned in the commission of a crime, whether they directly commit the act constituting the offense or aid and abet in its commission, or have advised and encouraged its commissions, are principles to the crime, which under this general statute, that means that if you aid and abet a crime, that you can be liable under the crime. It's possible that a prosecutor someplace might state that, go beyond the existing limits that are in the total abortion ban, limiting any action to just those who are licensed professionals. They might rely on this aiding and abetting criminal statute to assert criminal charges against those who aid or abet or assist a criminal abortion. Don't know how that will play out. Arguably, the legislature intended to limit the liability for aiding and abetting because that's what it did in its most recent pronouncement in 18622. It specifically set the penalties, and the penalties are simply adverse licensure action. But we don't know exactly, the Supreme Court and others, they haven't addressed how the aiding and abetting statute, whether it can be used or might be used as a basis for criminal prosecution. Again, that's another one of these areas that we're going to have to flesh out or wait for somebody to teach us. Now, there's a separate provision in the abortion statutes that says that no hospital nurse or other healthcare professional shall be deemed in violation of 18-606 if in good faith they are providing services in reliance upon the directions of a physician or other hospital admission, or upon the hospital admission of a patient for an abortion on the authority of the physician. So this would protect nurses and others who act at the direction of a physician and participate in the abortion. So it was meant to provide some protection to those nurses who assist a physician in the abortion. The problem with it is this particular protection only applies if they're being deemed in violation of, it says that they're not going to be in violation of 18-606, which of course is that statute that was essentially trumped by the 18-622. So it's not clear whether or not this protection would still be in effect. My take on the whole assisting, aiding, or abetting situation, at least while the Judge Windmill's injunction is still in force, I think it's unlikely a provider would be prosecuted for advising a patient of their care options, which include the possibility of obtaining an abortion in another state where it's legal, or counseling, transferring, or providing records to facilitate a lawful abortion in another state where abortion's legal. But there's no guarantees. I mean, you've got that decision out there, or at least that letter from Attorney General Labrador. We're not exactly sure what the status of that is at the AG's office, what position they're taking on that, but it's still out there, so it can cause you concerns. Nevertheless, I think you're relatively safe because remember, other provisions of the Idaho law requires you to obtain informed consent, and informed consent includes treatment options and getting a legal abortion in some place out of state. That's part of what you would need to get in order to get informed consent. In addition, a provider should not be deemed to be aiding or abetting a crime if the abortion's legal where it's performed. So if they're assisting with an abortion that's legal in Oregon, for example, then they're not assisting something that's illegal in Oregon, and therefore there shouldn't be a crime. Also, prosecuting persons for actions that performed in another state where the actions are legal raises serious constitutional concerns. Also, as far as just transferring records, the patient has a right under HIPAA to direct you to transfer records over to another provider. So that shouldn't give cause. So I think that the risk is relatively low in these types of situations, but you're going to want to take, steps to protect yourself. So at least from my view, some providers' permissible talking points and talking with a patient might be, you can certainly give them any information that's relevant to informed consent, which should include care options, alternative risks and benefits, which could be, obtaining an abortion in another state. But I think that you would want to make it clear that you're advise them that Idaho law prohibits most abortions. You could also tell them that if you want to transfer their care someplace, including a provider who may perform a lawful abortion out of state, that you can take appropriate steps, or you will take appropriate steps to transfer their care. That's just kind of part of the standard of care, and I don't think that that should violate the total abortion ban, especially when HIPAA would require you to transfer those records. And the Idaho Medical Practices Act generally requires you to transfer records at the patient's request. I don't think it's a problem for you to say for more information about treatment options, including lawful abortions, you might contact whoever it is might be able to give them information about that. I think that there's probably a low risk in that. But, we'll have to wait and see. It's kind of strange times. As I mentioned, Idaho did pass a new abortion trafficking statute. It prohibits recruiting, harboring, or transporting a pregnant minor within Idaho to obtain an abortion, including an abortion out of state, with the intent to conceal the abortion from the parent or guardian. If you do that, then you can get up to 2 to 5 years in prison. I know this caused a lot of people concern. I have less concern about this particular statute because it only applies when you're doing it with the intent to conceal it with from the parents or guardians, and it's an affirmative defense if you get parental or guardian consent. So if you want to assist a minor in obtaining an out-of-state abortion, you should be okay, at least under this abortion trafficking law, as long as you make sure that you have parental consent or the parents know about this particular situation. If you do that and you document it, then you should be okay under this particular statute. Let's talk briefly in those very rare cases where abortions are permissible to save the life of a mother, or in the case of rape or incest. Those other limitations on abortion that have been in effect for a long time, those other conditions, they didn't go away. They're still out there. So you still have to comply with all of those other situations, including under Idaho law, only a physician may perform an abortion. During the abortion can only be performed if it's done because of rape or incest. It can only be performed during the first trimester under the total abortion ban. Under these separate provisions, even if it's necessary to save the life of a mother, during the first 13 weeks of pregnancy, the abortion must be performed in a hospital or in a physician's regular office or a clinic if properly staffed, etc. After 13 weeks of pregnancy, the abortions must be performed in a hospital. The foregoing rules likely do not apply to the termination of ectopic or non-viable pregnancy because under the total abortion ban, those are excluded from the definition of a pregnancy and the definition of abortion. And at least according to the Supreme Court opinion, you'd probably fit within the medical emergency situation, the exception under the fetal heartbeat ban. Except in a medical emergency, the provider must determine the probable post-fertilization age of the unborn child through appropriate tests, examination, and inquiries of the pregnant woman. That's something that was part of the 20-week abortion ban, and it hasn't been removed. So theoretically, you're supposed to do that, but it really seems irrelevant now under the total abortion ban. You've got to obtain informed consent from the pregnant woman, of course. In the case of minors, there's additional specific requirements that you have to jump through in order to get consent for abortion on a minor. Generally, the minor can't consent to their own care. You'd have to get consent from a parent or guardian, or you'd have to go the judicial bypass route where you get authority from a court. Except in a medical emergency, at least 24 hours before the abortion, you've got to provide the required health and welfare information, the DHW information that they provided and posted out there. You've got to provide that to the patient and advise the patient of their right to obtain an ultrasound. If the ultrasound is used for the abortion, you've got to allow the patient to view that ultrasound image. Except in an emergency, medical emergency, before performing the abortion, you've got to determine if there is a fetal heartbeat and report in the record the test results and the estimated age of the child testing method and the date and time of the test. That's part of the fetal heartbeat statute. Again, for the total abortion ban, it's kind of irrelevant, but nevertheless, it's a requirement, presumably, for if you want to avoid liability under the civil heartbeat statute. When it comes to using chemical abortions, Idaho has a separate statute dealing with chemical abortions. And unfortunately, when they passed the total abortion ban, they didn't state how the two relate. So theoretically, you still may have to also comply with the chemical abortion statute if you're going to try to abort using chemical abortifacients. Abortifacients are defined to include mifepristone, misoprostol, and I apologize if I butchered those, and or other chemical or drug used to cause an abortion. It does not apply to the use of such drugs to treat ectopic pregnancies. That's based on the statute itself, the chemical abortion statute. Again, it's not clear to what extent the total abortion ban supersedes the chemical abortion statute. There are a bunch of other requirements out there for permissible chemical abortions. They require you to jump through certain steps before you can be involved in a chemical abortion. You have to comply with the state reporting requirements. Those are still out there on the books, so that within 15 days of an induced abortion, the attending physician must complete, file, and submit the induced abortion reporting forms to the Bureau of Vital Statistics. If the physician performed an abortion without providing to the patient the required information and ultrasound information, they've got to basically report themselves to the Department of Health and Welfare. All right, one interesting issue is, well, what is the liability of a pregnant woman for getting an abortion? Under the total abortion ban, it states that nothing in this section shall be construed to subject a pregnant woman on whom any abortion is performed or attempted to any criminal or conviction or penalty. But note that states nothing in this section, meaning section 18-622. Well, the problem with that is we have a separate statute still on the books, Idaho Code 18-606, which is in a different section, states that every woman who knowingly submits to an abortion or solicits of another for herself the production of an abortion, or who purposely terminates her own pregnancy otherwise than by live birth shall be deemed guilty of a felony and shall be fined. So you have these possibly two conflicting statutes that are out there. The total abortion ban says that you can't go after them under the total abortion ban, but this other statute still on the books which says you can. So we don't know exactly how that's going to play out. We do know that the Supreme Court, in their opinion, said that the total abortion ban, 6-week ban in civil liability law, imposed no criminal or civil penalties against the mother who submits to an abortion, but the Supreme Court did not expressly address 18-606. Now, arguably, the language in the total abortion ban, is what the legislature intended, that it wasn't, the mother wasn't going to be subject to criminal penalties, because that's the later expression of the legislative intent, and arguably that controls, but it's not entirely clear because the legislature did say nothing in this section as opposed to the other section. So that's another mess out there that at some point somebody's going to have to clean up along the way. All right, as far as additional resources, as I mentioned, I've got a lot of client alerts talking about the various stages of the abortion situation, including a guide that summarizes kind of where we are on the abortion stuff, the stuff we've talked about. If you'd like to access that, you can just go to our website or go to the link that I gave you at the beginning of the program and you can access that. That is it. That is a quick overview of the status of the Idaho abortion laws, at least as I see it, and as they exist today. That could change at any time depending on what the Ninth Circuit says or how some of these other lawsuits play out. We'll try to keep you updated on those things. If you have any questions about these things we've talked about today, you're not the only one. I have a lot of questions also. But if you'd like to send me an email, I'll do my best to answer those. Thanks very much. Appreciate your participation.